Afternoon, everybody. Thank you for joining us for today's webinar, How to Address Marijuana in the Workplace, the Challenges of Measuring Impairment. Today's webinar is part of the Partnership for Drug-Free New Jersey's Workplace Program, which is Drugs Don't Work in NJ. This program provides business owners, nonprofits, and government agencies in New Jersey with free assistance to establish and maintain a healthy, safe, and drug-free workplace. As you all know, adult use of marijuana is now legal in New Jersey, and sales of marijuana started earlier this year, which has created a challenging situation for employers that want to maintain a healthy and safe workplace. The purpose of today's webinar is to give members of Drugs Don't Work in NJ a better understanding of how to handle marijuana use from a workplace perspective, giving special attention to measuring impairment and the current status of one piece of the new law, which has not been fully set in place yet, which is the role of the Workplace Impairment Recognition Expert, or WIRE. And we have some great experts today who I'll introduce in a moment, who will help us gain a better understanding of this topic. But first, just a little additional housekeeping. As Greg mentioned, the webinar will be recorded. The slide presentations will also be available to attendees later on. And as mentioned, the questions, please enter them through the chat, and we will get to as many as we can at the end. Now, I'd first like to just introduce our expert speakers for today. We have Steve Trimbley, who is a partner at Trimbley and Olenowski. He specializes in labor and employment law on behalf of management, representing public and private sector employers in the full range of labor and employment law issues. The Partnership for Drug-Free New Jersey presented him with our Drug-Free Workplace Founders Award for his work in providing legal guidance related to substance use and misuse in the workplace. We also have with us Captain Seamus Geddes, who has been in charge of day-to-day operations of the Franklin Borough Police Department since 2019. He has 19 years of experience in law enforcement. He's certified as a drug recognition expert, and he is a certified drug recognition instructor for the state of New Jersey. And lastly, we have Andre Laney, an attorney from the Employers Association of New Jersey. She's a former senior trial attorney for the Equal Employment Opportunity Commission, where she litigated employment discrimination cases in federal court. She has served as an EEOC judge, conducting hearings and resolving discrimination charges brought by federal employees against all federal agencies. Andre also served as employment counsel and labor relations director for the city of New York. So we welcome all of our experts today and appreciate their time and sharing their expertise with all our attendees today. So we'll start with Steve, who will give us a good opening and outline of where we stand right now from a legal perspective. Steve?
Good morning, everybody. Good afternoon, everybody, and welcome to our webinar. As you heard, we're going to talk about the challenges of workplace impairment. I am first going to give you an outline of the law as it stands now, and our other panelists will take it from there. You'll hear me say next slide frequently to cue the slide that you're seeing on your screen right now. I will tell you that at its meeting of May 24th, 2022, the Cannabis Regulatory Commission, or the CRC, reported that in the first month alone, there were over 212 cannabis transactions purchased in New Jersey, amounting to total sales of over $24 million, and that's only the first month. So this is going to become an increasingly serious issue for employers to grapple with. Next slide. Quickly, by way of introduction, under the CREMA, which is the acronym for the statute that legalized recreational marijuana sales or cannabis sales in New Jersey. First, an employer cannot refuse to employ a person due to the presence of cannabinoid metabolites in that person's bodily fluid if it resulted from cannabis consumption, with the sole exception of employers who are under federal contract or federal funding conditions to the contrary. Next slide. And also, employers cannot refuse to hire, terminate, or take adverse action against any person because that person does or does not use cannabis products. An employer cannot take adverse action against an employee solely because the employee tested positive for lawful cannabis. A couple of points to make at this point. First, you notice that the use of the term cannabis, that is not a coincidence or inconsequential. The law distinguishes between cannabis, which is the product sold by licensed vendors to adults aged 21 or older, not to exceed 6 ounces at any given time, which is legal. It is distinguished from marijuana, which is anything else, which is the bootleg stuff that you might purchase from a drug dealer. The protections we're talking about for employment apply to cannabis. They do not apply to users of marijuana. That's a point to bear in mind as we go through this discussion. Next slide. Before we go on, I should point out that these employment protections have no exceptions other than as may be required under federal law, such as drug testing for commercial drivers who hold commercial driver's licenses. As we sit here today, there is no exception for police officers, no exception for teachers, no exception for childcare professionals, no exceptions for substance abuse treatment professionals, no exception for construction, no exception for manufacturing or any other safety sensitive position. So it is all encompassing, and which is why emphasis on current impairment is going to be critical. I also noted here this statute, which is not part of the recreational marijuana statute, but is a separate enactment, that when you interview a candidate, you cannot ask about, rely upon, or take adverse action based on a history of several low-level marijuana hashish offenses accepted for law enforcement, corrections, judiciary, homeland security, and emergency management. This statute took effect on July 1 of 2021. I know the Drugs Don't Work New Jersey and the partnership have material on this that you can consult, and they will make available to you that will describe the statute in greater detail. Now let's move on. Next slide. All right. Under the recreational cannabis statute, drug testing for lawful cannabis use is allowed under 4 circumstances: the reasonable suspicion of cannabis use while performing work responsibilities, observable signs of intoxication related to the use of the cannabis item, following a work-related accident subject to investigation by the employer, and also allowance for not only random testing, but also pre-employment screening and regular screening of current employees to determine drug use during prescribed work hours. However, there is a catch. Next slide. Adverse or corrective action cannot be taken based on a positive test result alone. There must be a physical evaluation to determine the employee's state of impairment, and it must be conducted by an individual with the necessary certification to opine on the employee's state of impairment or lack of impairment related to the use of a cannabis item. As this is written, the certified expert must determine, 1, whether the employee is impaired and whether that's related to the use of a cannabis item. Next slide. What exactly do we mean by impairment? The National Safety Council offers this definition of workplace impairment: the inability to function normally or safely as a result of a number of factors. And as you can see from the definition, it can be one of many factors. But the key is the inability to function normally or safely. And this determination must be made by an individual who is certified to make that determination and to tie it to cannabis use. Next slide. Now, the statute authorized the Cannabis Regulatory Commission to create a workplace impairment recognition expert certification program, also known as a WIRE program, in conjunction with the New Jersey Police Training Commission. The CRC is authorized to allow certified drug recognition experts who are law enforcement officers specially trained and certified to identify impairment due to substances, that they may be allowed to function as WIREs. WIRE training is to be offered or may be offered to full or part-time employees of your company or to independent contractors to identify cannabis use impairment and also to assist in accident investigation. We will return to this point shortly. Next slide. Despite the protections offered to cannabis users, we as employers are not required to allow any kind of cannabis activity in the workplace, including sale or even possession. We are not required to allow cannabis use or intoxication during work hours, And there's an escape clause that would allow otherwise protected cannabis-related conduct to be prohibited if that conduct would result in an adverse impact on the employer who is subject to requirements of the federal contract. So if you are under a contract with the federal government and you are required to maintain a drug-free workplace, including cannabis or marijuana, you will have an exemption from the statute to the extent necessary to comply with that federal contract. Next slide. However, the flip side of this is our right and obligation as employers to maintain drug and alcohol-free workplaces are neither restricted nor preempted by the recreational marijuana statute. This means, among other things, as you know, that the Occupational Safety and Health Act of 1970, which requires employers to provide workplaces free from recognized hazards that are causing or likely to cause death or serious physical harm, that obligation is not relieved. At some point, the obligation under OSHA and the obligation to not discriminate against cannabis users is going to come into conflict. And the statute tells us that we are not relieved from compliance. That would also apply to the New Jersey Safe Workplace statute. Next slide. Further, no state or federal law pertaining to employment matters is in any way amended or affected. So if there's any federal or state law pertaining to workplace safety, you are still subject to it. No person is required to violate a federal law. No person is exempted from federal law or permitted to obstruct the enforcement of a federal law. So again, if we're talking about commercial drivers who hold commercial driver's licenses, if we're talking about railway employees who are subject to drug testing requirements under federal law, which to this day still includes marijuana cannabis, you are still subject to that federal law. The state law is no defense. And cannabis use by persons under the age of 21 remains unlawful and unprotected. They do not get the employment protections we spoke about earlier. Next slide. Among the laws not affected by the recreational cannabis law is the Jake Honig Compassionate Use Medical Cannabis Act. And the importance here is, under that law, an employee who tested positive for marijuana cannabis must be given written notice of the opportunity to request a retest of the original sample or produce evidence of a legitimate medical explanation, and to do so within 3 working days. That is still on the books. That is still going to be a requirement, even if you have a positive test result for cannabis, and even if you have a wire or other certified expert certify impairment, the person still must be given this written notice in 3 days to produce a legitimate medical explanation or a legitimate evidence that he or she was using lawful cannabis, such as a receipt from a vendor, a licensed vendor. And as I stated, the recreational cannabis statute does not amend or supersede this requirement. Next screen. All right. Now we get to the question, what about the wires? As you heard at the opening discussion, we really don't have a wire program in place yet. During its meeting of May 24th of this year, the General Counsel for the Cannabis Regulatory Commission gave a 6-minute presentation, and the conclusion was essentially, we're still working on it. They also discovered when they met with the Police Training Commission, which, as you recall, they're supposed to be working with to develop a DRE or a wire program, they learned that the Police Training Commission does not train drug recognition experts, the state police do. So as matters stand, they are directed to work with an agency that is not familiar with drug recognition expert training. In the interim, last August, in its interim rules regarding the cannabis market and cannabis regulation, the CRC took the position that until the wire certification program is developed, no physical evaluation of an employee being drug tested is required. That causes many attorneys, including myself, some concern because it's contrary to the statute. And anyway, it's an interim rule that's going to expire on the 19th of August of this year. We will see what, if anything, the CRC does to replace it. An open question is whether employers can train or retain their own impairment experts. The statute does not specifically say that only experts certified by the CRC may conduct this evaluation. So it remains open for an employer to contract with perhaps a certified drug recognition expert from New Jersey, a certified expert from another state, working with the International Association of Chiefs of Police to develop a separate training program and receive certification and use those experts in place of a wire, or at least pending a wire program. That's still an open question. And finally, the elephant in the room, which is State versus Olenowski. In 2019, our state Supreme Court was asked to determine whether drug recognition experts truly are experts in impairment recognition, or whether they're no better than you and I in making that determination. The court decided that it was a complex issue. They appointed a retired judge, Joseph Lisa, to serve as a special master and conduct hearings. This decision was made in November of 2019. Due predominantly to COVID, those hearings did not start until last September. They are still ongoing. My information is that briefs have been filed and we are awaiting a decision from Judge Lisa, at which point the matter will go back to the Supreme Court for re-argument. And that, if we get a decision in that case by the end of the year, I think we'll be lucky. There is reason to believe, because at least one commissioner said so, that the CRC is waiting to see what happens with the Olenowski case before they proceed with the wire program. And if that's the case, it's going to be a long wait before we see any wire certification regulations adopted. And that's where we are now from a legal perspective. Thank you for your attention. We're now going to turn the seminar over to Captain Giddis, who's going to tell us about some of the more practical aspects of determining impairment. Thank you.
Thanks so much, Steve, for that review of many things, but also highlighting the questions that have we're still waiting for answers on. So we appreciate you getting us started today. And I'd also like to mention how grateful we are at the Partnership for a Drug-Free New Jersey to Steve for all his help and assistance in updating our drug-free workplace toolkit for Drugs Don't Work and NJ members. A lot of updates specifically focusing on the recent changes to policies and procedures related to the legalization of marijuana. So the revised kit is now available on our drug-free workplace website. You'll see some info on how to access that in the chat, as well as in the follow-up email that you'll be getting following the webinar. But we thank Steve for all your help on that, and invite everybody to make sure you check that out to see the latest in the toolkit. As Steve mentioned, our next speaker is Captain Giddis. One of the questions we get so often when it comes to marijuana and from employers is, how do employers go about measuring impairments? So we brought in Captain Giddis to hopefully shed some light on that and ways to measure impairment. So Captain Giddis, I will hand it over to you.
Thank you so much, Matt. Good afternoon, everybody. Captain Seamus Giddis again. These slides that I have here are from a presentation that I do called Know the Signs, which dives into all the drug categories that DREs look into when they're measuring impairment. If you could, next slide, please, Matt. Okay, I know that we're speaking about cannabis, we're speaking about marijuana, but the important thing, and this is from a law enforcement perspective, is what is a drug? So what is a drug to anybody? Some people think that when they think drug, they think, okay, cannabis, they think heroin, they think, illegal prescription medication. Drug in a law enforcement setting is any substance that when taken into the human body may cause impairment. So one of those substances could be rat poison. One of those substances could be lighter fluid. So it's important to not, paint with such a, you have to paint with a broad stroke, because the drug itself is all encompassing. It's not just the marijuana or the cannabis. And especially when you're talking about your employees, there could be other avenues for which they're being impaired. But I know that we're going to stick to cannabis, but that's just a definition I wanted to throw out to you all. If you could, next slide, please, Matt. All right, so we are talking about cannabis. We're talking about cannabis, obviously in the legal sense. We're talking about marijuana in the illegal sense. The primary psychoactive ingredient in cannabis is delta-9 THC. That's where you get your impairment from. Just some statistics for you guys. As of last year, domestic marijuana was about 4.89% pure, so a little under 5%. Non-domestic, so stuff coming in, was around 12%. The hash and the hash oils, which is becoming way more prevalent than the straight up raw marijuana, you're looking at about 30%, purity. The dabs, which is probably the most popular and the most popular thing that we see as law enforcement, because of the fact that they're 95% pure THC. And from an impairment perspective, we're seeing that cannabis, and this is again from a law enforcement perspective, that we're seeing for people that are operating motor vehicles, which is what the DRE is used for. It's usually a 4 to 6 hour shelf life, depending on the potency of the cannabis or the marijuana that they're getting. Next slide, please, Matt. All right, so this is just for reference, guys. It's obviously, I think that we've all seen what marijuana looks like, but I wanted to just show a couple of quick slides for the people that haven't seen it in quite some bit. This is exactly what raw marijuana looks like. Just some street names for it are the reefer, the grass, ganja, Mary Jane, hash, and you can see all theirs. Why is it important that we know this? It's important that we know this from an employee perspective, because this could be being talked about in your organizations or on your work sites. So it's important to understand that there are street terms, that there's going to be street terminology that employees are going to use as kind of like a workaround to get around flat out saying like, hey, I smoked marijuana, or I have cannabis on me. They're not going to, I highly doubt that that's the conversation that you're going to hear. So they may say like, I have some Mary Jane, I have some hash, I have a little bit of boom. So it's just important to understand that this is what's out there. Next slide, please, Matt. Hashish, guys, this is what hashish looks like. Okay, it's extracted from the cannabis plant. It's extracted using, you're normally using butane and butane torches, which I'll get into later. It's brown in color, okay, and it's usually smoked or ingested. You could put it in baked goods, but this is kind of what it looks like. It looks kind of like almost like a ground coffee with like a little bit of a brownish green tinge to it. So again, just for reference to see what it looks like. Next slide, please. The THC oil, this is probably the most important and probably the thing that we see the most. Again, it's extracted from the marijuana plant with a butane torch, lighter fluid, stuff of that nature. Can be baked, smoked. They usually put it in baked goods, or they'll actually, ingest it orally alone. So again, just as a reference for you guys to see. Next slide, please. The dabs. Okay, let me kind of break this one down a little bit more, because this is something that I think gets overlooked quite a bit, but is very important. Again, it's extracted from the plant. So everything that you can see the redundancy, everything is being extracted from the actual raw plant. Okay, and it's using carbon dioxide or butane. So the butane torches and the carbon dioxide is going to be important, and I'll show you why in a little while. Again, same thing. This is the potency. This is the potent aspect of the marijuana plants, or the marijuana category itself. These are the ones that are the 90 to 95% THC. So it doesn't take a lot for you to get that overwhelming impairment, that impairment that people are seeing now, where it may even cause hallucinations. So it's important to understand that this stuff is around, and it's actually easier to get in some certain circumstances than the raw marijuana itself. The street names for this are Moon Rocks and Butter and 710. The 1710 that I want to touch on, that means if you turn the number 710 upside down in your minds, it spells the word oil. And 710, July 10th, is National Marijuana Oils Day. So these are things that, again, the person that doesn't have the training may not understand. But if you see one of your employees walking by, be like, hey man, you got some 710. This is what they're talking about. They're not talking about straight up marijuana or cannabis. They're talking about the dabs. They're talking about the oils, the waxes, those kind of products. So again, something important to understand. Next slide, please. Again, just a reference, guys, marijuana wax. This is exactly what it looks like. It's kind of disgusting looking. It looks sort of like earwax if you look at it. But again, same thing. It's 10 times more potent than the regular marijuana that you see. So it's got those effects, and those effects could last a little bit longer than the 4 to 6 hours, which, is important in everybody's, field of work, especially if you're operating motor vehicles, if you're operating heavy machinery, if you're engaging in any kind of behavior that requires you to have some kind of attention span and some kind of, balancing, then, these could be, this could be quite an issue if they have this in their system. Next slide, please, Matt. All right, this one, I'm not sure if anybody's ever heard of, but it is around, marijuana shatter. Basically, the reason why they call it the marijuana shatter, it is just the wax and the oils that are burnt, that are melted down and they're baked. But basically what it is they'll take it. It's just like a cookie sheet. They bake it up and then they throw it on the ground and it shatters. So it's just another way for them to make it, another way for them to ingest it. It's kind of like that brittly texture, and will you normally be smoked or ingested orally. Next slide, please, Matt. When it comes to the products, I think this one probably takes the cake right now, is the marijuana edibles. Because as you can see, this is just one picture of, I mean, there's millions upon millions of different ways that they package the marijuana edibles. But you could see, I mean, this looks exactly like, unless you looked at the packaging and you looked at that label very carefully, you're going to see that this looks exactly like regular candy. And again, the discerning part, or the part that is a little bit concerning for anybody, it should be concerning for anybody, is it takes a little bit longer for the edibles to break down in the system, to digest in the system. So you could eat, half of, one piece of candy, and in 20 minutes, you're thinking to yourself, well, I don't feel anything, like this is garbage. And then you ingest the other half, when technically you probably should have only ingested that first half if you were going to do it, because it hasn't hit you yet. And then that's what you're seeing. You're not seeing the overdose type effects, but you're seeing the irrational behavior. You're seeing the hallucinations, because people are ingesting a strong amount for that particular person, for their system to handle. So that's why the edibles are very dangerous in and of themselves. And the way that they package them, at least in my opinion, you're looking at it, from an adolescent perspective. I mean, they're packaging these to make them more appealing to our adolescents, from our adolescents moving up. So it's dangerous, because if your children, I have two young children, if your children get their hands on something like this, could potentially be very dangerous. So it is something to look out for. Next slide, please. This is one thing I did want to touch on, is the THC acid, because it is starting to make a comeback. There have been cases from the Northeast, probably like the Buffalo corridor, where it actually came through Passaic County in New Jersey here. And when they tested this was a picture that was taken from, was 99% THC. So, I mean, it almost looks like, if anybody is familiar with what methamphetamine looks like, it almost looks like a methamphetamine. But this was actually THC acid. So again, just another way that you have to worry about how the product is being packaged, how the product is being sold, how the product is getting out on the streets. Next slide, please, Matt. The Delta 8, this is known as weed light. Okay, this was the stuff that was being, before the legalization of cannabis. This was the stuff that was being sold in all the health food stores, in the vape shops. They called it weed light because it had under the regulatory amount of THC, so it was able to be sold legally, and it's still obviously sold. It can cause the cannabis type impairment, but it obviously would take a little bit more and a little bit longer to get into the human body. But again, just something that you want to look at. Again, it looks exactly like the Delta 9 THC. It's just called Delta 8 because it has just that little bit less THC in it. And the picture that you see with the would be on my right, would be the actual packaging for the gummies. Again, looks very appealing to the adolescent population. So it's something we have to look out for. Next slide, please. The CBD oil, I'm not going to go too crazy with this. That's been around for a long time, but again, it is something that is out there and was being sold. This picture right here was being sold in a store. You're not supposed to, when you're selling CBD and CBD oils, it should only be 0.03% THC. This one was obviously 18% THC, so you can see the difference. This should not have been sold legally, but again, using it in vaporizers, they can use it in e-cigarettes, Juuls. You could bake it, you could drop it in your eyes, and the list goes on and on. So for sake of time, I just wanted to continue to move on. So if you could please, Matt. Synthetic marijuana, guys, is making a comeback. This was the K2 spice, the fake marijuana, as they say on the street, was sold as a, the thing with synthetic marijuana is they will change the chemical property of the K2 spice. So if the K2 spice is basically just ground up spice, and they just sprinkle chemicals on it. So that chemical may be, could be rat poison, could be anything, and they would just sprinkle it on there. So when you had the big spike in K2, especially in New Jersey, you saw that irrational behavior, that behavior where it was unpredictable because you didn't know what was in it. So you had the K2 spice, which was just regular spice, but it was mixed with different kinds of chemicals. So that's why this is way more dangerous, at least in my opinion, in terms of regular marijuana and regulated marijuana and cannabis is because you don't know what you're getting. And what they would do in the stores is normally gas stations or health food stores, vape stores, is they would have these packages. They would be banned, federally, they would be banned. The chemical that was in it would be federally banned. They would just change the chemical property, put it right back on the market. So it was very hard to follow. It was very hard to keep up with the K2 spice. It kind of went away, but as of 2018, it's definitely started to make a comeback, at least here in Sussex County where I am. You're starting to see the gas stations bring it back out again. The vape stores are bringing it back out again. So it's definitely something to look out for. Again, you can see from the picture, has a little bit of a different look than the raw marijuana, the raw cannabis, but very similar in viewing. So next slide, please. All right, here's a synthetic marijuana packaging, guys. Same thing. I mean, if I'm looking at this packaging, I'm looking at it like, okay, well, they're trying to gear this towards our adolescents, towards our children, to get them to buy it. And these packaging, what you could see is if you flipped all these packages around, I could guarantee you that they sell them as a potpourri or as a incense is what they'll put on the packaging. And that's how they'll actually sell them out. But again, they were banned. Now they're back again. So it is something to look out for. If you see packaging that looks like this and you turn it around and it says, this is just potpourri, not for, not edible, or this is, this is any kind of aromatic substance, this is probably what you're looking at. So, and it is, if ingested, could potentially be, could give you that hallucination type impairment that you would see with any kind of hallucinogen that you ingest in the human body. Next slide, please. Just a picture of the synthetic marijuana, guys. I'm not going to go too crazy into it. This is just one that we saw at one of the stores here that we took a picture of. Next slide, please. All right, so the indicators that you're going to see, okay, and this is from a DRE, from a drug recognition expert standpoint. These are the ones that you're going to primarily see.
Okay, and Andre, we're right up to your slides here. So if you want to step in and begin your presentation, and like I said, if Captain Geddes is able to rejoin us, we will have him go at the end of this. So Andre?
Yes. Good afternoon, everyone. My name is Andre Laney, and I'll be speaking with you about how we take the current legislation that impacts whether and how employers can regulate marijuana use by their employees and cannabis use more broadly, and determine how best to manage your discretion and authority as an employer seeking to create and maintain a safe workplace, and how certain steps that you take could actually create greater legal risk for your organizations in your effort to maintain safe workplaces. Next slide, please, Matthew. Okay, so what I've done here is set forth the graphics, if you will, showing the 3 steps that go into implementing CRIAMA, and that's the latest recreational marijuana legislation here in New Jersey. So as an employer, you're going to, at the first stage at least, make an initial observation. It might not be your observation, it might be that of someone who reports the incident to you, but it will be one that has to create a reasonable suspicion that the individual has used marijuana on the workplace or during work hours, or signs that this person is intoxicated. Whether they're intoxicated by alcohol or marijuana remains to be seen, but they are behaving in a manner that indicates that they are intoxicated. So if that were the case, this is where drug testing pursuant to one of the 4 types that you can do. We know about pre-employment, random, we know about post-accident, but I'm talking about the type where the person has reported to work, either has been observed with cannabis or observed in an intoxicated state. Where you have that scenario rise, then you will want to, as an employer, in the absence of a wire, a certified wire, and as previously noted, we don't know when the final certification standards will be created. You want to have some objective indicia of the person's current use or current intoxication. So you're going to need to comply with the spirit, if not the letter, of this current legislation. Some objective indicia, pictures, witness statements, something to indicate that the person actually was holding cannabis in her hand during the course of performing her work, or was observed to be ingesting cannabis, or some other objective indicia. Now, then, if you were to get a drug test, understand that the drug test would have to comply with all of the standards that, as employers, particularly those of you who have administered drug tests in the past to your employees, it would have to be done in an objective, scientifically reliable way, using procedures that acknowledge the individual's right to privacy and confidentiality. In other words, certain precautions would have to be taken on the part of the employer to ensure that the employees were not subject to the potential of an invasion of privacy, because you, as the employer, even though you are trying to maintain the safety of your employees and your workforce, would then be subject to an invasion of privacy claim, for example, if that test were misadministered. So next slide, please. What happens then if you perform the test in the manner in which it is supposed to be done, and the person turns up and tests positive? Well, as noted in the prior presentation, under the Jake Honig Act, the individual has to be given 3 days written notice and an opportunity to present either a medical marijuana card or some other, and I quote, legitimate medical explanation for the presence of cannabis in their system. Likewise, they can also challenge the validity of the finding or request a retest at their own expense. Now, this remains the case even if the person does not have a medical marijuana card, or at least one that you know of, because you don't know whether or not they have that status. And if they were to have a medical marijuana card, you should obviously be aware of your obligations under the Americans with Disabilities Act to engage in an interactive process to determine whether, and if so, how you would be able to accommodate their ongoing use of that particular form of medication. Next slide, please. So with that understood, I want to draw your attention to these two acts. The Jake Honig Act does govern how employers interact with and deal with employees, particularly after it becomes known that they are medical marijuana card users. And similarly, CREAMA, which is the act that also imposes certain obligations upon employers with respect to the use of their employees of marijuana recreationally. As I note here, both acts prohibit employers from taking adverse employment actions against employees simply by virtue of their having a medical marijuana card or having been found to have used marijuana off duty. So to that end, it's important that you understand that an adverse employment action could represent anything from working, or rather sending the person home from work without pay, or disciplining them in some other manner, or terminating them. But it does give employers in both instances the right to take such adverse employment action against an individual who has used this cannabis product at work or during work hours while engaging in work for the organization. So understanding that, it's important that you, in getting that positive drug test result, engage in the discussion with the employee to determine whether they are a medical marijuana card user. And even if they are not, you have to have some basis other than the fact that they have marijuana in their system to engage in adverse employment actions. That doesn't tie your hands entirely, but as I said, particularly in the absence of the standard certifying wires, workplace intoxication recognition experts, that is going to be a challenge for employers to demonstrate that they had an objective physical examination and standard for determining that this person was intoxicated. Next slide, please. So when can you take adverse action? As I said, if the person is using cannabis at work and has been observed to do so, that is your evidence that this person is not afforded the protection offered by either the J. Koenig or CREAMA acts. And if the person has their in their possession the cannabis, that also would be a basis to terminate them. If you have objective bases that deal with the person's work performance or conduct, those are your best bases for determining that an adverse employment action, be it discipline or termination, should be taken against the person. Next slide, please. Now, the Employee Assistance Program, EAPs, can serve a beneficial purpose under this new terrain that we're all navigating, because they can provide education to employees about the potential negative consequences of cannabis use. They can also provide resources to help those who are addicted or who are having adverse work performance issues, address those challenges. However, as an employer, do understand that because of the prohibition against exerting or imposing adverse employment actions on those individuals simply because of their off-duty use of cannabis, you cannot punish someone for having used cannabis unless you can prove it was at work or that they were intoxicated at work. Accordingly, your directing someone to EAP cannot be a punishment. And if you are using it in that punitive way, then that's going to violate the policies. So what do I mean by that? If you send someone to EAP, it should not impact their potential for promotion. It should not impact their salary or their income during the period of time that they are sent for EAP. Now, you may say, why should I be paying them to go to EAP? Well, it can come out of their accrued sick leave if they have it. But it has to be administered in some way so that it is clear that the objective was not to punish, but rather to assist the person with their challenge to overcome the effects of cannabis. Next slide. I provide this slide simply so that you can see there is a context for the challenge with which we are faced here in New Jersey. We are not the first state to legalize recreational cannabis, nor have we been the last. Others have come after us. Next slide. Cannabis does, as we understand from Captain Geddis's presentation, have a direct physiological impact on individuals. What we're trying to determine, and part of the challenge in quantifying just how much cannabis or how recently one's use of cannabis will impact their work performance, I have no way of judging. However, I did go to the Bureau of Labor Statistics census for fatal occupational injuries, not a cheerful read, but nonetheless, I did go to that to see whether there was any significant increase in the number of workplace fatalities within those states which had legalized recreational cannabis within, for example, these past 11 years. And the states that I've included, Colorado and California, both had recreational cannabis legalized prior to New Jersey. So as you can see here, there does not seem to be a significant increase. Certain states seem to lead the way as far as workplace fatalities in terms of the numbers. However, there doesn't seem to be a significant increase between the time when these particular states did not legalize recreational cannabis and when they did. Next slide. Now, that may or may not in part be because of the type of vigilance that I'm encouraging employers to use in administering their policies, but do understand that there are going to be challenges because, for example, in this case, Hager versus M&K Construction, this is a case from last year, it involved an employee who suffered a workplace injury for which he was prescribed medical marijuana and for which he submitted a request for workers' comp reimbursement. His employer refused to facilitate his getting reimbursed for his use of medical marijuana on the basis that they felt this was a conflict between their obligations under state law and their obligations under federal law. And as previously noted by Mr. Trimbley, this is still an unlawful drug under federal law. So that said, the employer said, I can't do it because this would be a violation of our obligations under federal law. The court did not agree. So even where you have some concern that federal laws might be implicated and federal laws that you must comply with might be implicated, you should seek legal feedback on whether or not CRIAMA is preempted by that federal law, because it might not be. Next slide. Now, workers' comp, just to clarify, workers' comp under New Jersey law does not cover injuries that are sustained by employees because of their intoxication, be it by alcohol or any other intoxicating substance, including cannabis. However, the challenge of proving that that intoxication was the sole cause of the injury is a fairly high bar. And so you have to be clear that just finding drugs in someone's system will not necessarily exempt them from workers' comp coverage. Next slide. That point was brought to bear, if you will, in this case, Tlumak versus Highbridge Stone. This is another New Jersey case from 2006. This case did not involve cannabis, which certainly would have been unlawful at that time, but it involved alcohol. The truck driver who sought workers' comp coverage did so despite having an over the legal limit amount of alcohol in his system, and despite the fact that he had caused significant damage to the employer's truck as well as other property because of the accident. And in this instance, the court upheld the workers' comp judge's assessment that alcohol was not the sole factor in his accident. And accordingly, workers' comp benefits were provided. So this is a challenge. This isn't impossible, but it does require that employers understand the laws with which they have to navigate and ensure that they manage their own expectations as to what they will be able to achieve, even if cannabis is found to be in someone's system during their time in the workplace. Next slide. All right, finally, I just want to let you know that there is legislation that seeks to create the kind of carve-outs that Mr. Trimbley spoke of previously, which would make it such that police officers, those who operate heavy machinery or carry weapons, or first responders, for example, would be exempt from CRIAMA. What does that mean? It would mean that if they had used cannabis off duty, they would still be subject to the potential for discipline. However, these are bills. These are not laws yet. I've included them here so that you can follow them, set up an alert for developments on whether these bills become law. But New Jersey is clearly aware of the challenge that awaits businesses here, and it seems that there are some pieces of legislation being created to address that. All right, thank you.
Thanks so much, Andre. I think you really was thorough explanation of all that's going on and all that people need to be aware of, and so appreciative of your time to share that expertise and to give our members such a good picture, a clear picture of where we stand, and that some things might not be clear at the moment, but very thorough, and appreciate that. I just want to let everybody know, all our attendees, that a poll just launched. We would just like you to answer all the questions on there and submit it before we end here. I know we're right at the time, 2 o'clock, where we're supposed to wrap up. So I just want to quickly ask our panelists one question, which is based off of the topic today and what we've spoken about, what would be, for employers here, what would be your one closing thought, most important thought that you would want to leave all our attendees and employers here with, based on this webinar? And Captain Geddes, I'll have you go first if you're reconnected.
Yes, can you hear me?
Yeah. Yes, I can. So yeah, Captain Geddes, if you want to start with your
Sure.
answer to that question.
Sure. First and foremost, I apologize for that, guys. It dropped out. I have no idea what happened. But secondly, I would just, when you're dealing with these topics, you got to deal with it with white gloves. I know that Mr. Trimbley had said it in his presentation, is that there's a lot that could, and there's a lot of gray areas right now. There's a lot of what ifs. There's a lot of, well, we'll see what happens. And I can say from a law enforcement perspective, and I know that Mr. Trimbley touched on it in his presentation, is we are up in the air. We're up in the air on terms of any kind of clarification on what the drug testing would be for law enforcement. What is marijuana or is cannabis even going to be on the law enforcement drug testing? Are they going to prohibit law enforcement from utilizing any kind of marijuana products? So, the thing I would say is it's going to be fluid. It's going to be ever changing. So do your homework. Make sure that you're constantly staying on top of the changes, the additions, because they're going to come rapidly. And I think that once they do, there's going to be some gray areas still, but just make sure that you're doing your homework before you make any kind of, judgments or any kind of decisions in terms of your employees.
Thank you, Captain Geddes. I appreciate that. Steve, would you like to just give your closing thought and most important thing for people to take away today?
I think a couple of things you need to take away. Number one, there is nothing that prevents you from disciplining or taking corrective action against somebody who appears to be impaired at work or is engaging in improper conduct just based on that fact alone. There's no need for you to determine what caused it, at least not immediately. If you see somebody who's impaired, somebody who's acting improperly, someone who's acting dangerously, that's grounds for taking corrective action alone. Don't feel that the fact that you can't test them to determine what is causing the impairment, whether it's cannabis, alcohol, prescription drugs, or catnip, is any reason to hesitate. And second, again, I have to bear in mind the difference between lawful cannabis purchased from a vendor and illegal marijuana. There seems to be this notion amongst too many people that it's open season on all marijuana items, and that is not true. I would also point out that from what I understand, California legalized cannabis through licensed vendors several years ago. As recently, I believe, as 2020, a study was conducted, and by far the vast majority of marijuana products used and consumed in California still come from the black market. That will not be protected under New Jersey law. And if you have any reason to believe that you have an employee who's using some of the black market materials that Captain Geddes was talking about earlier, these protections that we discussed today will not apply to them. And that's important to bear in mind.
Great. Thank you, Steve. I think that's so helpful for everybody to walk away with today. And Andre, would you just like closing thought and what people can leave today with as they go conduct their businesses?
Certainly. I do think that Mr. Trimbley hit it right on the head with his observation that an employer's right to discipline an employee is only hamstringed if he's basing it on the test results. So if you base your decisions as to how you regulate your employees on their conduct, on work performance, that provides a greater degree of latitude and discretion to the employer. Whatever decisions you make, if you make them based on these legitimate objective bases, will afford you the greater level of protection. So ask yourself, do you need to do testing in order to make certain assessments about your employees, or can you merely increase your level of vigilance, at least during this time where many of us are operating in a greater gray area than any of us would like to?
Thank you, Andre. Again, that's also very helpful, and we're so appreciative for that. I want to thank all of our speakers again for really providing such useful information today. I want to just remind everybody that the slides will be available up on the website afterwards. So if you had missed anything or just want to refer back to some slides you wanted to check again, they will be available, as well as the recording as mentioned. And just a few other things I want to just mention: the drug-free workplace toolkit, which you see the website right up there in front of you right now. Please access it. You can get all the up-to-date needs. As a couple of our speakers mentioned, it's such a fluid situation. So the toolkit is really a great resource to stay up to date on what you need to know, and to constantly get the information you need as it's occurring. So we will continue to update that toolkit as updates are needed. But please just know that that's always there and is always a resource for you. And I just want to let you know that you can also email Bill Lillis, who is the drug-free workplace coordinator for partnership and Drugs Don't Work in NJ. That his email address is bill@drugfreenj.org. And Bill is another one of those great resource for everybody. Bill is always available throughout the year to answer those questions that you might have, or at least get you to the right answers you might be needing. And if you didn't get that email, it's also in the chat right now for Bill, his email. So just check that as well, and you'll have those resources. But again, one last time, just phenomenal job by our presenters. Thank you so much for your time today and for sharing all this important information. We want to thank all our attendees today for making time, and just want to wish you all a great rest of your day and rest of your week. Have a good one.